Good afternoon, everyone, and welcome to our second webinar session for advanced directives. Before I begin, I want to discuss a little housekeeping for everyone. If you have any questions during the presentation, please put your questions in the chat. The chat button or feature is at the bottom of the screen. It's a little bubble with 3 dots that says chat. You can put your questions in the chat, and then I will get them at the end of this presentation and share them with the presenters to give you a response. We are recording, as you know, all of these sessions, and we will share the slides on the IDOA Ombudsman page, and then you also can find it on our YouTube page, and Lee Moriarty should be dropping that link to our YouTube page in the chat. So I want to thank everyone for joining us for this important webinar in understanding advanced directives. And this is presented in conjunction with the Illinois Guardianship and Advocacy Commission, the Long-Term Care Ombudsman Program, and the Illinois Department of Public Health. This is our second of 3 webinars that are being held this month. And we also want to thank the Illinois Pioneer Coalition for allowing us to use this platform. We are grateful to have residents and family members, caregivers, and advocates joining us for this important discussion about understanding advanced directives. I want to thank you for taking the time to invest in this important conversation, and we hope that today's session is informative, engaging, and helpful. And now it is my pleasure to introduce our presenters from the Guardianship and Advocacy Commission, Laura Spahn. And Laura has served as an attorney for the Legal Advocacy Service, a division of the Illinois Guardianship and Advocacy Commission devoted to providing trial and appellate representation to persons with mental illnesses since 1993. Ms. Spahn represents respondents in involuntary commitment and involuntary treatment proceedings at trial level, and has urged mental health care cases in 5 districts of the appellate court and in the state Supreme Court. She's spoken at national and state mental health conferences and also co-authored a chapter on mental health law in an Illinois guide for lawyers. She will also be in your ear about powers of advanced directives and why it's a good idea if you are adult to have one, and if you're in perfect health right now. And then also with Laura is Lee Moriarty, our Deputy State Ombudsman for the state of Illinois. So please join me. And Lee is going to talk a little bit about advanced directives from the Ombudsman's perspective. So please join me in welcoming Laura and Lee to talk about understanding advanced directives. Thank you.
Thank you so much, Kelly. I just want to start out by saying, yes, I think advanced directives are the very best. I think all adults should have one. And I want to, let's see. I want to show you that I am not just the president of the fan club, as it says here, but I am also a client. This is my advanced directive. I'm trying to move some of the images I'm seeing on my screen. Just a second here. I want to show you that this is my own advanced directive. This is my own power of attorney for healthcare that you can see that I did in 1992. So this is ancient, but it's still valid. You're going to learn a little bit later on that a power of attorney can be, one and done, but you can also modify these documents. But this one is the one that I did in 1992. And you can take a look at it. You can see it's ancient because it was printed on a dot matrix printer. The ones that had the little, the little things on the side that you'd have to tear off. If there are any young people out there, you have no idea what I'm talking about. But thank goodness documents don't look this fuzzy anymore, but yes, this is still a good document. Um, I don't know why I felt like I had to put my whole name here. Like there are going to be other people by that same name. I don't know, but it's kind of cute. All right. Um, the purpose for doing these is that you act now to maintain control of your health care. But you may say, why do we bother with this? And I want to go back in time a little bit. Some people in the audience may remember Terry Schiavo. And you can see here, Terry has her 1980s clothes, her 1980s hair. Um, Back then, she had something happen which resulted in some brain damage. And then there was quite a fight over whether she should have life support, life sustaining treatment removed. There were battles between her husband and her parents. So her case actually went through the court. This was a case out of Florida. It went very high up through the court system. The court finally determined what her substituted judgment would be. That is, she couldn't express what she wanted, but based upon her lifestyle and her wishes, things she may have said, what was determined that was that Terry would not have wanted life prolonging measures. And she was eventually permitted to die. But that was after 7 years of court and various governments' involvement, state and federal. And it was 15 years after her brain damage. So this just gives you a little bit of history. And there were advanced directives at that time, as you know from my 1992 one. Um, Terry Schiavo and I happen to be the same age. I just turned 63. So that gives you an idea of, you know, how far things have come since that time. But as far as advanced directives go, they're still kind of young and we're still getting used to them and people aren't doing them. Or people are thinking, oh, that's just something that you think about towards the end of your life. No, do it now, even if you are in good health. You don't know when there might be an accident, or you don't know when there might be a time when you can't voice a decision for yourself. So this is something every adult should have. I want to talk with you about 3 purposes of advanced directives. So the principal is the person who makes an advance directive. So as the principal, you get to make choices now about how you're going to be treated in the future, in case there's a time in the future when you can't make decisions for yourself. So that's empowering. It can help to make court intervention unnecessary. You don't want to have a judge making a decision for you. So it can help you avoid court. I want to point out here too that with an advance directive, a person making an advance directive is proactively picking someone to make healthcare decisions for them in case of a future incapacity. Now that's compared to guardianship, where a decision maker is imposed on you and you lose your decision-making ability. And maybe that person is somebody you would want to be your guardian, but maybe not. So an advance directive leaves the power with you. So a third purpose is with an advance directive, treatment can happen right away if you're not able to voice a decision for yourself. And there can be information in the advance directive so that there's no need to reinvent the wheel. And then what happens is faster recovery. So my acronym about advanced directives is EAR: empowerment, avoid court, recovery. And, basically, I'm saying that an advance directive allows treatment providers to hear your wishes, even if you can't voice them for yourself, even if you are, determined to be incapable of making a healthcare decision for yourself. So these are the powers that are covered by a power of attorney, or an example of some of the powers. You'll see there are all kinds, from lab work to surgery to admissions to a facility to dental work. Power of attorney is very broad. So we're talking about two different kinds of advanced directives today: a power of attorney for healthcare, and then there's also its subset. Oops. A mental health treatment declaration. A mental health treatment declaration only covers three things. It covers two kinds of treatment: psychotropic medication and electroconvulsive therapy, and it covers admission to a mental health facility. So we're going to talk about each of these today. So we're starting with the power of attorney for healthcare, and it's very, very broad, represented by the full football field here. And it's meant to provide broad coverage. This is some of the language from the power of attorney for healthcare. It's intended for an agent to give any kind of decision about any kind of healthcare decision, whether it's I don't appreciate how there's a distinction between physical or mental condition. It's all medical conditions. So I would say it allows for an agent to make both psychiatric and non-psychiatric decisions. And the agent can agree to admission to any kind of hospital or facility, which includes a mental health facility. It allows the agent to have access to all the records. And again, there's just a confirmation that this is meant to be as broad of authority as possible, so an agent named under a power of attorney for healthcare is able to make decisions, and that includes withdrawal of nutrition and hydration and life-sustaining measures. I'm going back to my ancient power of attorney for healthcare. Even back then, even back in 1992, that broad power language was there. I have it highlighted for you. So this is not anything new. Now, turning to the Declaration for Mental Health Treatment, we just have 30 yards of the football field. And that's because the Declaration covers only those three things. This is the language from that Declaration for Mental Health Treatment. The Declaration covers psychotropic medication, electroconvulsive therapy, and admission to a facility. Now, anybody making either a power of attorney for healthcare or a mental health treatment declaration can narrow any kind of decision, put a condition on it, put a limitation on it. So that's something to keep in mind too. And we have had clients do that. So it yes, they are intended, there is an intention that these can be broad. They can also be narrowed. The duration of these documents. As I mentioned already, the power of attorney, you only have to do that once and it's done if you're happy with it. It can be modified though. Um, a mental health treatment declaration is only good for 3 years. It's going to expire 3 years from the date it's executed unless it's in use at the time, and then it's going to continue in validity until the principal regains capacity. But otherwise, that 3-year period, it goes pretty fast, and you need to renew a mental health treatment declaration. The power of attorney is going to require naming an agent, and that agent is going to be the person who speaks for you if there's a time when you're not able to make decisions for yourself. And you don't have to just name one agent. Well, you do have to name one agent at a time, but you can name successor agents in case the first agent is unavailable. The mental health treatment declaration, you can also name an agent. In that document, the agent is called an attorney in fact. It's the same thing. It's just a little bit fancier language. And you can also name a successor. But with the mental health treatment declaration, naming an agent, naming an attorney in fact, is optional. And that person does not have to be an attorney despite that designation. Attorney in fact is an agent. But some people like to do a mental health treatment declaration because they might not have a trusted person they can name as their agent. Both documents have to be witnessed, but you have to be careful about who the witnesses are. The power of attorney, you only have to have one. The mental health treatment declaration, you have to have two. Now, these documents do not have to be notarized, but a notary public can be a witness. Importantly, the witnesses can't be certain people, because the idea is you don't want to have the appearance that this document was imposed on anybody. This document has to come from the principal. And you'll see there are certain people who aren't allowed to witness it because you don't want it to look like somebody was pressured into making this document. So these are the people who can't be witnesses for both documents. It can't be the agent or successor agents, and it can't be any relative. And then for the power of attorney, it can't be certain treatment providers, and it can't be the owner or the operator or their relatives of a place where the person is staying if it's a healthcare facility. And for the mental health treatment declaration, it can't be the primary doctor, and it also can't be any mental health service provider or relatives of those people. And this is really, really broad. So you can see that for a power of attorney, a hospital case manager or social worker could be a witness, but they couldn't be for a mental health treatment declaration because they're a mental health service provider. So it's important to be cautious about who is witnessing these documents, because you don't want there to be a need for the advance directive to be activated, and then there's a question because a witness is challenged. I hope that makes sense. Sometimes hospitals will have the hospital chaplain serve as a witness. And that's really good. Our office is always ready to assist with these, and we can serve as witnesses. Changing your mind once you've done an advance directive. Um, we will let young people know. Sometimes younger adults will name um, a parent as an agent, and then we'll name another their other parent as a successor. And we'll say, oh, you can modify that at any time. Say in the future you have a significant other. You might want to modify your advance directive to make that person your primary agent. So so these documents can be modified at any time. Powers of attorney for healthcare can be revoked at any time and by any means. It can be torn up. You can say, I revoke this document. You can tell somebody you revoke it. You can write on it, revoked. Um, but recent legislation has changed the power of attorney so that there is now a 30-day delayed revocation that you can opt for and check a box so that if there is any concern that you might revoke your power of attorney at a time when you most need it, there's a sort of a 30-day waiting period where your power of attorney can still be in use, even though you have indicated that you want to revoke it. This is the language of that. If you are concerned you may revoke your power of attorney at a time when you need it the most, you can initial this box at the end of the form that you would like a 30-day waiting period. This means your agent is making decisions for you during that time. This is purely optional. Here's the box that you would check. A lot of the clients that we work with who do powers of attorney for healthcare, our clients, a lot of our clients have mental health concerns, and they do decide to elect this box because they don't want to go to all the trouble of having a power of attorney for healthcare and then risk revoking it at a time when they most need it. And we also caution agents under a power of attorney that sometimes it's better to not act under a power of attorney if somebody is looking to revoke their power of attorney. And this is because, a power of attorney is good for many reasons. If a power of attorney is being used for maybe mental health treatment or maybe treatment for dementia or something where a person may be upset that the that a power of attorney is being invoked. Maybe it's better for the agent not to act, so the power of attorney will be in place for other types of non-mental health or non-dementia types of healthcare that the person may need. And sometimes there can be a standoff between an agent and a treatment provider. So if there is a power of attorney that is activated and a treatment provider says, hey, we want to give this treatment, and the agent says, absolutely not. It's better to kind of work on a solution rather than risk some type of pursuit of involuntary treatment for the person who took the time to make an advanced directive, or for the, or to risk maybe a guardianship where somebody else is then appointed to make decisions for the person that they wouldn't want. So these are just some things to think about. Changing your mind with a mental health declaration. This is harder. It's harder to change your mind about a mental health treatment declaration. Remember, these are only good for 3 years. So you're kind of making a commitment when you enter into one of these. So to change your mind, you have to do it in writing. And it has to be signed off by a doctor. The doctor has to say that you have the capacity to revoke it. Now, when do these documents go into effect? With the power of attorney, it's the principal who decides, or the principal chooses how that's going to work. Here are three options directly from the power of attorney for healthcare. If you are not having a storm and your electricity is still on, you have already read these several times by now. So the first one is the most keeping the power to yourself. You get to make decisions. Your doctors will decide when you lack the ability to make decisions. The second one allows you to make decisions, but you're sharing information with your agent. And a lot of times clients of ours will actually pick this one because sometimes it is nice to have people having information without constantly having to sign releases of information to share those documents with others. And then healthcare personnel will talk with your agent. The third one is for people who are maybe, I would suggest maybe these are for older people who are ready for somebody else to start making decisions for them. All right, next slide, please. Okay, so a mental health treatment declaration goes into effect when two doctors, and then you can keep clicking till there are words at the bottom. Two doctors or a judge find that the principal is not able to make decisions for themselves. And I want you to know, in our experience, there are always two doctors who are willing to make this determination and document it. So we have not ever had to go to a court and ask a judge to make a finding that a principal under a mental health treatment declaration is not able to make decisions. There are always doctors we have found who are willing to do this. And you get bonus points if you recognize the two doctors on the left, if you recognize the television show that's from. Okay.
It's a good show.
Very good show. All right, now the next slide, and this is going to be one of the handouts that you'll be able to access, as I understand it, through the website.
Through the the Illinois Long-Term Care Ombudsman Program website.
Yeah, so there will be a few handouts from today that you can access. And this is one of them. And it's a kind of a cheat sheet that lets you know the differences, lets you kind of compare and contrast declarations for mental health treatment versus powers of attorney for healthcare. You can see that there are similarities. I mean, both of these documents can be limited or conditioned. They both require witnesses, of course, and there are limits on who can witness. But the declaration has to have two. The power of attorney has to have one. One requires the agent. One doesn't. The document can speak for itself. So that's maybe a better document for a person who doesn't feel that they have somebody they can trust to name as an agent. The declaration is very hard to revoke. The power of attorney is pretty easy to revoke unless the principal opts for that 30-day delayed revocation. The declaration, it's only going to cover those three types of mental health treatment and admission. The power of attorney can be very broad. So this kind of helps to figure out what you want to do. If you don't like either, next slide, please. If you don't like either, you can always write a personal statement of wishes. And this personal statement of wishes could be evidence that a court could use to help determine substituted judgment. There's that word again from the beginning when I talked about Terry Schiavo. What is what is a person's substituted judgment? What is, if we don't know what the person would want because they can't tell us, what do we know about them? What have they said or done that would help a court determine what their substituted judgment would be? So a personal statement of wishes might do that. Okay, next slide, please. I'd like to run down through our storyboard now and see how many of these stories we can cover. They're stories that I think help people understand advance directives. We're at about 3:41 p.m. Is that the right time?
Yes.
Okay, all right. So I'm just going to start talking about these, and I will try to speed it up if we're getting short for time, but I think we're doing all right. Cynthia. Cynthia is a person who was in a hospital, and she needed some treatment. She was alleged to need treatment for what was thought to be a mental health condition. She had had a mental health condition before and had done well on some medication. At the same time, she had also had a medication that had caused very serious side effects for her. Her mother testified in court because there had been a petition for involuntary medication that was filed. Her mother testified in court that Cynthia had very severe reactions to a medication. The medication is called Haldol. It's also called haloperidol. And Cynthia had even had to go to the emergency room before because of her severe reactions to this medication. And her mother did not want her to have that medication again. Now, the doctor was requesting a package of medications, a grouping of medications that included Haldol, included haloperidol. And the law in Illinois is that if there is a medication package requested, you have to either grant it in whole or deny it. Unless, if there's a medication where a doctor says, oh, that's not good, I understand now that's not a good medication, I'm going to withdraw it from the package, and here's why. But that didn't happen in this case. The doctor continued to request the entire package, and the judge granted it. On appeal, the appellate court said that was wrong because the benefits of the medication did not outweigh the risks to the person. And you'll notice there's no advance directive that's part of the story. But what I want you to think about is, what if there had been an advance directive? What if the person at the center of the story had said, oh, I'm going to do an advance directive because I don't ever want to risk getting that particular medication again. I'm going to do an advance directive, and I'm going to narrow it to say, I do not authorize my agent to consent to Haldol or haloperidol. If that had been the case, I don't think that order would have been entered. I don't think the doctor would have asked for that medication. Maybe the case would not have even gone to court because the agent would have been able to consent to something other than Haldol. So that's why I want to include Cynthia's story in this presentation, just to give you something to think about. We are on the slide that says, what is your story, right?
Yes, we are.
Okay.
Yep, we are.
Hatsu is the next person. Hatsu was an 80-year-old Japanese-American woman. She grew up during World War II. and had been in an internment camp. She had at some point in her life, electroconvulsive therapy. And she had said, I don't want to have that again. And eventually, she included that in a power of attorney for healthcare. She did not grant authority to her agent to consent to electroconvulsive therapy. Well, she's 80 years old and she's in the hospital. She's having some depression, and she had both her advanced directive, a power of attorney for healthcare. She also had a guardian, same person, and her guardian sought authority to consent to electroconvulsive therapy for Hatsu. The court ordered it. Now, Hatsu appealed that case, and the electroconvulsive therapy order was stayed pending appeal. That meant that she did not get electroconvulsive therapy while that appeal was pending, while the appellate court was reviewing the trial court's decision. The trial court's decision was, the appellate court's decision was that the trial court was wrong. The trial court erred because Hatsu's advanced directive should have controlled that decision. And that, the guardian did not have the ability to make a decision that went against the power of attorney for healthcare. It kind of shows you the strength of these documents. The next story is about Gloria. Gloria is somebody who had bipolar disorder, and she also raised 3 just lovely children. And Gloria was somebody who always wanted to take her medication so that she would be able to raise her children, and didn't want to have to have anybody worry about her. And as her children got older and were off to college and then getting their own careers and doing well, she wanted to make sure she did a power of attorney for healthcare so that her adult children would be in place if there were ever a time when she would need a healthcare decision made. And she felt like she didn't want to be any burden on her family, and she always wanted to make sure that she was in good shape, and her grandchildren, etc. She was always there for her kids growing up, and she always wanted to be there for them as they went out into the world. So Gloria had been on a particular medication for many years for her condition, and after a number of years, and she's been doing well, there wasn't any problem with it, but her doctor said, Gloria, you've been on this medication for many years. Why not try something different? There are some newer medications that have come out. Might be worth a try. And Gloria said, well, whatever you think. Okay. And the medication did not work well for her, and actually had kind of the opposite effect on her. And Gloria had to be in the hospital. And it had such a bad effect on her that she needed to have maybe like a medication readjustment, and she was not in a position to be able to make that decision for herself. And so her power of attorney was activated, but she was quite mad about being in the hospital. She was upset, and she said, I don't want anybody else making decisions for me. And no, I don't want my children making decisions for me. And she revoked her power of attorney at a time when she most needed it. And Gloria spent the next several years in in the hospital, in and out of the hospital with involuntary treatment orders. And it just is terribly sad, because this was a person who was always trying to try to avoid that. And the 30-day delayed revocation is in part, a response to Gloria's situation and others like her. People who go to the trouble of making an advance directive, but they don't want to revoke it at a time when they most need it. And arguably, this was just no fault of Gloria's. I hope that makes sense. Let's turn to another person. Turning to Gilbert. And I will say also that some of these are actual names. Some of these are pseudonyms. Ahatsu is an actual case that you can look up. It's an appellate court case. Gloria and Gilbert, these are pseudonyms. Gilbert is a person who always wanted to have a mental health treatment declaration. And as I said, they expire in 3 years, unless they're in use at the time, and then they will continue until the person regains capacity to make decisions for themselves. But Gilbert had a situation where he happened to require a hospitalization and need for treatment at a time when his mental health treatment declaration had expired, and he had not gotten around to redoing it yet. So he was in the hospital. He didn't get the treatment as quickly as he would have had his advance directive been in place, and there was an involuntary order for treatment. So it just shows you, this is an example of, these sometimes these are not perfect. You've got to stay on top of them if you're doing one of the advance directives that's, an every 3-year renewal one. Turning to Craig. Craig is a case that you can look up. There was first an appellate court case, and then there was an Illinois Supreme Court case. And this is a case where a person had been in a hospital and had medication, and at some point after that did a power of attorney for healthcare and named his mother as his agent. And then Craig was at some later point in the hospital and needed treatment. And the doctor said to his mom, to his agent, we would like to be able to give, this package of medications to Craig. And we have determined that Craig does not have the capacity to consent to these medications. So we're coming to you as his agent and asking for you to consent. And the agent took a look at the medications and said, oh my goodness, Craig has had some of these particular medications before, and they have caused some bad side effects for him. I can't consent to these. I can't in good conscience consent to these. And so the doctor, rather than working with the agent, the mother, said, all right, then I'll see you in court. And then went to court and got an order for involuntary treatment that included those medications. And that was appealed. And the appellate court said, well, that's all right, because the agent wasn't agreeing with the doctor. We're gonna let the involuntary order stand. And that was appealed to the Illinois Supreme Court. And at the Supreme Court level, there was even a professor from Southern Illinois University who submitted a friend of the court brief to support Craig's position on this and talk about the whole history of advance directives and the reason for those, et cetera. And the Illinois Supreme Court at the time said, you know what, we're going to carve out an exception for people with mental illnesses and say, yeah, if the agent doesn't consent, then it's okay to go to court for an involuntary order. So this is why we say agents, if there is a dispute with a treatment provider, you want to try to work something out. You don't want to have that battle and have a doctor run to court to try to get a court order. I also want to mention in that Craig case, there was no constitutional issue that had been raised. So if this comes up again, it's possible there would be a different outcome if that was looked at from a constitutional perspective. So that was that's a reason why we say maybe you don't want to just say no to everything if you're an agent. And I hope that makes sense too. Please ask questions if it doesn't. Okay, let's turn to the case of Brittany. Now, Brittany came after the Craig case, and Brittany is a young person who was, a student and had been in the hospital and had some treatment, and after that did an advance directive and named her mother as her agent. And maybe, I can't remember the exact time frame, but maybe about 5 years later, Brittany was hospitalized again and was thought to need some type of treatment. So there was a petition for involuntary medication that went to court. And what happened in Brittany was it was discussed in court that Brittany had an advance directive, but nobody heeded it. Nobody heeded the advance directive, not the attorneys or not the judge. And it was found on appeal that was wrong, that there should have been attention paid to the advance directive. And the court cited in Brittany that, hey, Craig's case showed us that advance directives can be very important and we should heed them. We can't just disregard them. We have to look at them first and talk with the agent. We have to check with the agent. And in Brittany's case, the agent was Brittany's mother and had been willing to consent to treatment, but they just blew past that and got an involuntary order. All right, last case on our storyboard here, Mrs. Beetler. Mrs. Beetler is a guardianship, an estate case. Mrs. Beetler is somebody who had there was a dispute among the family. Mrs. Beetler lived with her husband, Mr. Beetler, and I think it was their daughter who thought that Mr. Beetler wasn't taking sufficient care of Mrs. Beetler. Now, Mr. Beetler was the agent under a power of attorney for health care for his wife. But nonetheless, the court granted the daughter guardianship of Mrs. Beetler, guardianship of her person. But the advance directive still stood. The advance directive was not terminated or anything like that. There was no suggestion that the agent was doing anything bad. So the power of attorney for healthcare was still there. And so Mrs. Beatler was, I think, moved out of the home to a residential facility. And Mrs. Beatler, I believe, was diagnosed with dementia of some kind. And Mr. Beatler, as the agent under the healthcare power of attorney, said, my wife really could use her dentures to be relined. So could we please get that done? And the daughter objected to that. And the court said, well, the guardian objects to that. We're not going to do that. And that was appealed. And on appeal, the appellate court said, Mrs. Beatler gets her dentures relined. If her agent under the power of attorney for healthcare wants her dentures relined, I think that would be good for his wife, then she gets her dentures relined. So that also shows you the power of these documents. The court said, yeah, that agency is still good. That power of attorney, the guardian doesn't have control over the powers that are included in the healthcare power of attorney. So Mrs. Beatler, the end result of that case was that the agency, the healthcare power of attorney agent, had the ability to make that decision on behalf of his wife, even though the guardian thought that was maybe a dumb idea for somebody living in a nursing facility and somebody with dementia. But the husband was still looking out for his wife. So that's maybe a sweet story to end on. Okay, we got through all our stories and we still have time, right? Okay, next slide, please.
I'm trying to advance it. It's not advancing. Hold on. There we go. There you go.
Okay. All right. So this is a quote from a professor of therapeutic jurisprudence. Therapeutic jurisprudence is kind of the idea that everything we do to recognize court processes and legal processes can have an effect on a person's life. So one of the things he says about advanced directives is that this very process of making decisions about future treatment could have an effect on a person's future condition, and it can possibly diminish the chances of future incompetency. The idea being that you have taken steps to ensure that you are empowering your own decisions. So I really like that quotation. And I just want to show you here, this is a screenshot of the Illinois Guardianship and Advocacy Commission's website. This is our division, the Legal Advocacy Service. So on the Legal Advocacy Service division part of our webpage, it has advanced directives forms that you can download. And also on the website in a separate spot, there is a guide to advanced directives, but that is also going to be one of the handouts that you can access on the ombudsman page.
Yes.
Did I say that right? Okay.
Yes.
So our advanced directive booklet is going to be something you'll be able to access. And that's going to give you a little more information and the ability to compare and contrast the documents. Okay, how about next slide? Is that the one that's the Illinois Supreme Court?
Yes.
Okay, so this is from our Illinois Supreme Court, and this is just recognizing that this is related to mental health treatment, but it covers any kind of any kind of treatment that is not forced upon somebody, but is free from compulsion, is going to be more therapeutic and more effective than anything that's forced on somebody. And this is important because when treatment is provided to anybody through an advance directive, it's considered voluntary because that person has made that decision in advance. They have made that decision in advance, and the agent is just voicing the decision on their behalf through that document. Okay, next slide, please. And this is just my card. So you're welcome to get in touch with me. Our office does help with advanced directives. We help with those with our people who are our clients at no charge. We're always willing to answer questions about advanced directives, help you to the forms, help you to the booklets. So you're welcome to get in touch. And I think the next slides then are yours, Lee?
Yes, they are. Yes, so I can take over from there, and I'll just going to keep you on. So if you have anything you want to share, please don't hesitate.
Okay. And Lee, just and Laura, we do have a question in the chat, but for the person that put the question, we'll answer your question at the end of the presentation. Thanks, Lee. Thanks,
Thank
Laura.
you, Kelly.
Hang on here.
Great, thank you. So I'm just going to talk about that in the advanced directives in regards to the ombudsman advocacy. So I've already explained about basically who it is that we do, what it is that we do. We advocate for people who live in long-term care. And I was going, as we were talking, I was leading to the next piece that we also do is we also work for people that are in community-based services through the state of Illinois. So we have a home care ombudsman program as well that can also assist with this advocacy. And our work is statewide for both that community-based and the long-term care. So know that we work throughout the entire state of Illinois. And I've mentioned previously that we do amplify the individual's voice by making sure that they achieve what it is that they need and they want and they deserve. So part of that becomes making sure about the powers of attorney. One of the things that we do notice as ombudsman is that sometimes when people enter into, for example, a long-term care community, let's say they go into a nursing home and they start to lose their empowerment. People start to not value their voice as strong as other people's voices around them. Many times that's family members, and that many times those family members are their power of attorneys. And so what we find is that people will say, a daughter might say, well, I am my father's power of attorney, so I'm running the show now. Even though Dad's voice may be very much in control and he has not designated her to be acting in his best interest at that given moment. He's only asked for her to kick in when he loses his voice. And his voice is still active and he knows what it is that he wants. And many times what we do find, though, is that the long-term care community listens to the daughter over that father who has not lost his voice yet. So this is part of what we will do is we will step in as ombudsman and make sure that everyone clearly understands that this gentleman does still have his decisional capacity and that he is in control of his care and the daughter is not the one to be there dictating what it is that he should be doing. We really do advocate for people when they take on the role of power of attorney is to remind them that they need to be acting in the manner that the individual themselves would want to be treated. So they have to be taking a look and putting their own biases aside and saying, what is it that my father would want? Not what is it that I want for my father. That's really important because when you take on that role of that power of attorney, you are not acting for what it is that how you would lead your life. You're supposed to be acting in how the individual would want their life to lead. And I will tell you, I am the power of attorney for healthcare for my mother. And we have conversations. My mother is 93 years old. And we just had a conversation 2 weeks ago just to realign things. What is it that she wants in her life now? Has that changed in the last 7 years when we really last had our last deep conversation about this? So these are things that we should be doing if somebody has asked us to be their power of attorney. We should be finding out what it is that the person needs, what they want, and what they deserve, and then we should be acting in that role. And also I've got my power of attorney all lined up as well, Lauren. And I have yes. And I've had it for several years, and my daughter is my healthcare power of attorney. And obviously, I've not lost my voice. So, one of the things that I will use many times when I'm talking with a long term care facility is, do you have a power of attorney? Who is that person? Do you still, if they kicked in and they started making decisions for you when you needed to go to the doctor with your healthcare choices, that wouldn't be right for you right now. You still have your voice. So, my daughter is not making my healthcare decisions because I have not lost my voice. And I would not expect for that to happen for anybody until those power of attorneys can technically be kicked in. So I just want to make sure that everybody knows that we are here as ombudsmen to be able to help and support. So Laura has shared with you how they're able to help as well as us. So you're seeing there's a lot of help out there when you get confused. The best way to reach through us many times could be through that senior helpline. You could Google Senior Helpline Illinois, and then it comes right up. That is 800-252-8966. Or you also can get a hold of me anytime through our program. It's just always the way the state of Illinois operates. First name dot last name at illinois.gov. So I am Lee Moriarty. It's Lee, Lee dot Moriarty, Moriarty at illinois.gov. Or you can always find the ombudsman for your particular area on our website. And again, we're on the Department on Aging's website under advocacy, long-term care, and advocacy for home health care. So please utilize our program and make sure that we're all making good, empowered healthcare choices for ourselves. With that, Kelly, then we'll go ahead and I'll stop the share. And if you want to go ahead and share the questions.
Sure. Thank you, Lee, and thank you, Laura. And I want to thank both of our presenters today. This information was extremely beneficial, and I hope that folks have taken a lot away from both. And I do want to apologize again for the technical problems. So the question that we have, Laurel, is the person says, I have a question on, I think it was Craig's story. Why is a doctor able to get involuntary treatment when a POA objects?
Well, in Craig's case, the Illinois Supreme Court said it was because Craig was a person with a mental illness, and the mental health code provides a mechanism for an involuntary treatment petition. Now, the mental health code also provides that if there is a petition for involuntary treatment, the power of anybody who has an advance directive, the advance directive must be attached to that petition. The person who is an agent, is supposed to have notice of it. So I think the court didn't get the answer right, and courts sometimes don't, and there are follow-up cases. And that's also what the professor of law at Illinois Southern University thought in the friend of the court brief. So, I would suggest that, looking at the history of U.S. Supreme Court cases too, sometimes things are decided one way, and sometimes later on they're decided a different way, the very same thing. So I can't give you a really good answer for that. But we continue to encourage people to do advance directives. If there is a case like Craig A in the future, we would approach it from a different direction. But we also encourage people to try to work with treatment providers I think in the Craig case, there was maybe just somebody who said, I'm not going to work with this agent. Not going to work with the agent. So I don't know, but what encourages me is that Brittany's case, which came after Craig, the court said, for crying out loud, there's an advance directive here. Let's make sure we are looking at that before there's an involuntary order, and we're talking with the agent under the healthcare power of attorney. So that was a positive thing. I hope that answers your question.
Is it okay if I go off mute?
It did feel that way when you were presenting it to us, that you weren't really quite sure if the court did judge the right way in the beginning. So that I think that brings it to light a bit more. But was there a further question to that?
The gentleman asked if he could come off of mute and I guess follow up.
Yes, go ahead.
Go right ahead.
Thank you. This was very helpful. I appreciate it. So in a situation like Craig and then Brittany, if a doctor fights the POA, the Advanced Health Directive, and then a future court decision goes against what was originally, or sets precedent against what was originally decided, can that doctor be sued for malpractice?
Oh, now you're getting outside of my realm. I do not
Okay.
do, that I don't do the malpractice types of cases. It can, if there's some type of a court order authorizing a doctor to give medication, the doctor has some legitimate coverage there to be able to give medication. So I don't know about that, but I think what would be a good idea for people who are doing advanced directives to do is to be specific in their advanced directive. If there are medications, I remember the Cynthia case. Cynthia was the person whose mother testified about her severe reactions to a medication. We have a lot of clients who in their advanced directives say, I do not want that same medication that gave Cynthia the severe reaction. Other people have had severe reactions to that same medication. And one of the reasons they want to do an advanced directive is so they don't risk getting that medication in the future. So, be specific in your advanced directive, and you are putting a medical professional on notice that really, you've had a problem with this medication in the past, and then I don't think they're going to want to give you that medication. I know of another person who had a medication, and one of the potential risks of the medication was rash. This person got a severe rash over their entire body and had to be hospitalized. And there were pictures of the person with the rash. In their advanced directive, they said, this was considered an allergic reaction. It was dreadful. And so that was included in their advanced directive, that this is a medication they do not ever want again, but they're willing to take other medications. And the advanced directive includes pictures of the person with that rash.
Mm.
So, so be as specific as you can. It's okay to put conditions or limits in your advanced directive.
That makes a lot of sense, what you just said there. Why not put more information onto it? Attach the picture, attach the level. Yes.
Writing, people take them more seriously.
Mm-hmm.
So you go to the trouble of doing an advanced directive and you have specific information in it. That's gonna, I would think that would stand out. if I'm a hospital counsel or a counsel to a doctor, I would say, I guess I would think probably better not to suggest that medication if a person has gone to the trouble of writing out why they don't want it. There are other medications you can give, right, doctor?
Yeah, there you go.
We don't have any additional questions. The gentleman said thank you.
Okay. And Kelly, did you want to close us out?
Sure, I can go ahead and do that. Again, I want to thank everyone for attending today. We have another session that will be coming up June the 24th, the same time, same place, and that would be on understanding supported decision making. If anyone missed any of the sessions that we've had this month, we will be repeating them next month on July 9th from 2 to 3:30 will be understanding guardianship. July 16th would be this session, understanding advanced directives. And July 29th would be understanding supported decision making. And again, those times in July is from 2 to 3:30. Our next session again is June the 24th at 3 p.m. for understanding supported decision making. You will be able to get the slides from today's presentation on the Ombudsman website through IDOA, and you can get the video recording on our YouTube page. Thank you, everyone, for joining us this afternoon.
Thank you.